Hi, everybody. Jose Luis Morales here. Welcome back to another episode of the Morales Group Show. Today, we have a repeat guest. The name is Jennifer Felton with Relaw. And today, she's going to be educating us on how to remove someone from a deed or how to remove somebody from title. In other words, a quiet title action. So, the reason I wanted to do this episode is I recently had a client who wanted to sell her property. However, during the foreclosure dates back in 2009, 8, 10, 11, and 12, to avoid foreclosure or to prolong the foreclosure, people were adding people on title that they had no idea who they were and basically clouding the title, which would delay the foreclosure process. But what a lot of times they didn't realize is that when you do that, it basically makes it so that these people, if you ever want to sell, you have to get signatures from them. And if those people aren't real, then you basically can't sell your property. So I wanted to do this episode because we don't believe that people realize the implications of adding people on title, removing people on title. There's so many different things. And we're going to be going over almost like a worst case type of scenario. Like, let's say you add somebody on title. They don't want to sign a deed to get off the title. What does that process look like? Welcome back to the show, Jennifer. How are you?
I'm good. How are you, Jose?
Thank you. Thank you for coming back on. So for our viewers that don't know who you are, who is Jennifer Felton, and then how did you get involved in real estate law?
Yeah, so I started out as an escrow officer. I did transactional real estate in escrow for 15 years. Loved real estate, didn't love being an escrow officer. Not the easiest job. So I went back to school, got my law degree, and now I practice in the space of real estate. So a lot of the same things I dealt with. I joke because like now that I'm a lawyer, people believe me. The answers are the same, but the belief with that ESQ at the back makes all the difference, I think.
That's so funny. The credibility now.
Correct.
So let's get right into it. So let's talk about that situation that I mentioned.
Yeah.
That person added 3 different people to the title with 1% interest, and then the signatures were different than the persons that were added on there. So it said John Doe, 1% interest, Mary John, 1% interest, and then the signatures had a different name on it. Have you ever seen that before?
During the foreclosure crisis, '07, the mortgage meltdown, there were a lot of people trying to strategize to help people from losing their homes, right? So the one of the strategies, there were these foreclosure rescue companies, they would call themselves, right? And most of them were really bad. Not all, but most. They would convince the homeowners to pay them their monthly payments instead of paying the mortgage company, right? And then they tell them that they're going to keep their home from being foreclosed upon. And one of the strategies that they would use was adding people on title. Technically, it didn't stop the foreclosure. The foreclosure could still occur because things are done in real estate on recording based on priority, right? And in California, priority is based on time. So that loan that is in default in a foreclosure situation was on title before these other people were added. So the lender's priority is higher than these third parties. But most lenders didn't want to foreclose over a third party. And so it would at least delay, if not stop the foreclosure for some period of time. People also did things like filing bankruptcies or other kind of delay, slow tactics. The sad part was these foreclosure rescue companies were taking all these people's money. The mortgage wasn't getting paid. And in most cases, they did end and eventually get foreclosed upon, right? Most of these people lost everything. But some didn't, right? Some, they were able to survive this meltdown and the lender is still in place, right? So they've still got their lender from '07, '08, right? But now they want to do something. Maybe they need to refinance. Maybe they're in a position to do that, or they need to sell, or, someone's passed away. Whatever it is, some sort of triggering event results in us finding out that there's these ghosts on title, right? Mm-hmm. Who are clouding title, and it keeps us from doing anything without resolving those title clouds. So that's what the situation your client is in, where she's, she would like to sell, but the ghosts on her title keep her from being able to do so.
Yeah, because basically there's three other people on title aside from her. So let's walk through that situation. That
Yep.
process is called the quiet title action, right?
Well, there's two ways to get someone off a title:
Uh-huh.
voluntarily or involuntarily, right? So voluntarily, if we were able to locate those three people and they agreed to sign a deed transferring their 1% in this house back to your client, that would be an option, right? So
Hmm.
there is a voluntary option. One of the things that I've seen when I deal with these types of situations is often the people that have been put on title don't even exist, right? They're not even real people. So even if they are real people, finding them, getting them to cooperate can be very challenging. It does happen. I've been able to resolve them that way in some cases, but if not, if a voluntary solution is not available, then the court is what's required. And so we file a lawsuit into the court and we ask the court to issue an order removing those people from title to the property.
Do these people ever ask for money whenever you're asking for them to be removed from the deed? And this is why we're stressing, like, whenever you're adding somebody on title, you're literally like, or let me ask it this way. Like, if you're adding somebody on title and they get in and they get a judgment against them, how does that affect them?
Well, that's it. You really want to be careful with your title, right? It's like cash, right? You want to put it in a safe place. You don't want to put it with someone you don't know or trust, right?
Hmm.
And as soon as someone else is on title, whatever, I call it warts, whatever warts they have attached to you. So, for example, a common thing is for parents to want to add a child to title to the property. The idea is avoiding probate. Probate, as you know, and most people, the word probate scares people, right? It's
Hmm.
a slow, expensive process that happens when someone dies and hasn't managed their estate. So we want to avoid that. So parents will add their children thinking it's going to avoid probate. Well, what if your daughter, who you added on title, goes and gets in a car accident, right? And the Bentley owner sues her for $1 million and wins, and now they have $1 million judgment against her. As soon as the abstracted judgment is recorded, that $1 million is now attached to your house because she's on title to that property, right? So not even somebody doing anything wrong, just the circumstances of life can result in claims and that ability. So anyone who's on title, anything that they have, a tax lien, right, a judgment, a creditor, can attach and go after your property. So we do not want to add anybody who's not contributing in most cases to the house, the mortgage, right, to on title. There are ways to do it that don't put those risks in place, right? So a trust is one option. The other in California and many states is what's called a transfer upon death deed, where you say, when I die, my daughter gets my property. But so she doesn't come on title. She doesn't, if something bad happens with her, it doesn't affect you. She only comes on title when you've passed away.
You passed
So
away.
you're safe, right?
Got it. Not only that, but like, let's say I see it very common in the Latino community where they'll deed a property over to the children for Medicare or Medi-Cal, like different misconceptions that exist.
Right.
And what they don't realize is that now they lose the step up in basis when the parents pass away. So there's so many implications that happen in that situation where you said that, let's say somebody gets $1 million judgment, but let's say that person is only a 1% owner that
Yep.
gets the judgment. How does that work?
It still attaches. The way that our system works, like the title system, is that once a judgment exists and is recorded, anything that is owned by that person is what's called attached. So the bottom line is that if the house were to be sold, that creditor would have to get paid. They would put in a demand and they would have to get
Wow.
paid. Not necessarily the whole $1 million, right? Like again, negotiation can happen, or you'd go to court and limit what they could get potentially. But they're a cloud, right? They're clouding that title, and now you got to deal with them. It's something, right? As an escrow officer, we dealt with liens and clouds all the time, and working with creditors to resolve that. Tax liens, The government wants their pound of flesh, right? Anything like that can attach, and then you're dealing with that creditor in order to resolve that issue.
It's funny because I was watching like a Instagram post by this influencer,
Yeah.
and he bought a property where the HOA does not allow for people to rent out the property. And
Yep.
his workaround was, I'm going to make the tenant a 0.0000001% owner. And it was funny because everybody was like, oh my God, that's so creative. What a great idea. And then I saw somebody post on there, and what
Mhm.
they posted was like, well, now you can't evict them because now they're technically an owner, or they said something like that. I don't know if that's true or not.
Well, it's a different. It's you're going to be dealing with a different process, right?
Yeah.
To get that person off a title, right? You're going to be dealing with either again voluntary. They're going to have to sign off and deed back their interest, or you're going to deal with a partition action, which we've talked about before,
Yeah.
right? Or a quiet title action, something like that. And in addition to then potentially a a eviction, right? And so ownership and possession are two different things, right? So understand that you have to deal with ownership issues with someone like that and possession issues. They're two different things. I had a case with a client who they bought a property for investment. It was him and another woman, and so they were on title together. And he wanted to sell, and she didn't think that they were selling it for enough money, so she occupied the house in order to keep him from selling. And so he tried to do an eviction. The court wouldn't do it. So then we had to go back. I don't do evictions. I would have not told him to do that, but he tried and it failed because she was an owner. And then we had to do a partition action to get the court to order it sold because she wouldn't let the house be sold. So yes, anybody on title can be a huge
Is a
risk.
problem. Yeah.
Correct. Well,
Yeah.
even
Not,
competency. What if someone, gets incapacitated? Now we can't get them off because they can't legally sign off, right? All kinds of things can happen.
yeah. And even including judgment. So if they do ask for money, like what have
Yep.
you seen in those situations where they're like, hey, look, voluntarily all come off the title, but
Right.
you've got to give me X amount of dollars? What does that typically look like?
It really depends on if you can find the people, right, and where they're at. So I had one recently that I think he ended up paying 25 grand to get these people off a title. And from a time standpoint and a cost standpoint, and so understand, let's kind of step back. A quiet title, just because I file a quiet title doesn't mean it just happens. Right?
Yeah. It's a
So our legal
process.
system is really, really slow, and cumbersome. And so if we're going to file a quiet title action, then we have to serve the people who we're trying to quiet title against. Well, service of process can take time, and we got to find the people, or we have to publish, which takes time and money. Then we got to prove our case, right? You're looking at a year or two, and easily $25,000 to do a quiet title action, right? So if you can get the guy to sign off now and you give him 20 grand, it's probably a good deal versus what it would cost and what the headache, the stress, the uncertainty of the alternative.
Even the time as well too.
Correct.
In terms of serving, it's funny because I understand that a lot of times people have to get served. How
Mhm.
do attorneys like find somebody? Like, are there services out there? Like if you have like somebody that on a deed, like how do you even go about finding them?
Well, we hope it's an unusual name, right? Like, Morales, how many Moraleses are there, right? Like trying to
Thousands.
find you is going to be really hard if I didn't
Very
know who
hard.
you were, right? If it's some unique name, right? There's databases and we have access to records that the public doesn't have access to, but I'm not like PI level, right? So there's our level, right? Lawyers have access to databases. We have to certify that we're using it for a legal purpose and all that, but we can get some data. That data is decent, but not always perfect. But sometimes we are hiring private investigators to go out
To go
and
look for people,
go find people. Um, and we have to show that we looked for them before a court will allow us to publish.
get
So
somebody off title.
right. If you can't find someone, right? If someone just has fallen off the face of the earth, you still have to prove that you tried to find them before a court will allow you to serve them outside of them being personally served. The process is called publication. So we get the court to give us an authorization, and in the newspaper, we publish the information, and that puts them on public notice. But to publish, you have to prove that you could not find them.
Got it. Okay. And then for the quiet title action, it sounds like the first step is to try to find them to see if you can do something voluntarily. It's probably in your best interest to try to do it and just pay them off, because the quiet title action is going to take some time. What's the process? Like, I know I've received partition actions. Usually an attorney will reach out to me and they'll say, hey, can you draft up a listing agreement for me? We're going to send it to the other party and see if they'll sign off, and we'll submit a letter with that listing agreement. What does the quiet title action process look like?
It depends on the circumstances. A partition action is generally agreed upon common ownership, right? Where most partition actions are family disputes, right? Like inherited family situations. Quiet titles tend to be random people, right? Much less structured in most cases. And generally, in a quiet title, there's no consideration, there's no money that the person who's filing the quiet title thinks is owed to the
other person.
It's an argument that someone is making an improper claim to my title, right? Whereas a partition, both parties or the parties are generally have valid claims. It's just, what are we going to do with the property? A quiet title is getting off people who should not
be on.
Right. That's much more of what that's used for. Well, I'll tell you, as attorneys, we'll put every cause of action we can think of in a complaint because we want to have as many options as we can. But as a general rule, a quiet title is designed for someone who's making a wrongful claim to title. So generally, the offer is not money. The offer is get off, or you're going to have to deal with me legally, right? And we'll send them a sample document to sign and try to get them to agree and cooperate. And if that doesn't work, then we'll move to the next step, which is filing the lawsuit and making it cost them time and money and effort to deal with.
How long does that process typically take from start to finish?
Yeah. Our legal system is really bad. Your best case scenario is a year, realistically 2 or 3 years. And if there's a fight, if there really is a claim from the other side, I mean, I have a case right now, we're on year 4. So a disputed case can take quite a long time.
So this is why you got to be really careful who you add on title, because that client that I have, she would be able to sell, but she's got very little equity. Now it's like, if it's going to take a year to 4 years of doing something, like your life changes completely in a matter of a year to 4 years. So it's actually really sad for her because she added the people. Now, in a situation where you don't know who the other people are, or in a situation that we talked about, like in the foreclosure days where people were just adding random people, like, is that still the same process, like a year to 4 years time frame?
Best case scenario is a year. Right. Because we have to do the service of process. So this all goes to the concept of due process, right? Our legal system is designed to make sure people's rights they're given every chance to protect their rights. And so even when someone has been the victim of a situation, the other side has to be given their chance. And so serving them, and where they don't exist, I got to prove they don't exist to get the court to let me publish. Right. So that's months of talking to a judge and trying to get through to them, and affidavits and declarations. And I have, on every case, I've been able to successfully do it, but it really depends on the judge, on what they need, how we got to satisfy them in order to get to the next step. Because once we can serve, then we can do what's called a prove up. So once we've served and everybody's been defaulted, right? So this is all the procedures, right? You file a complaint, you serve it, The other side has an opportunity to respond. If they don't respond, there's a default procedure. Again, this is all civil procedure. Then we file what's called a prove up. And in a quiet title action, the prove up has to be a court hearing. They can't do it without a hearing. So now we got to have a hearing where we prove to the judge that we are the owner of the property. So think about timing and court and all that. Your best case scenario is a year.
What is typically the part that takes the most time in that 1 to 4 year process?
Well, again, if it's disputed, we're in discovery, we're dealing with pleadings, we're maybe going to a mediation or an arbitration, right? Like there's a lot that could go on in that process. In an undisputed process, it's several months to do the service of process and several months to get a hearing. Our legal system is not in high speed.
Like when you say disputed, meaning the other person saying, "Hey, I actually have a ownership right in this
Correct.
property." Basically, you're saying I don't have an ownership right, and I don't. Basically, got
Correct. So in most cases with quiet title, like the stuff we're talking about, where there's these random people, they're not going to come fight and say I own the property, right? They don't have any documentation to prove. They didn't pay a mortgage payment, right? They didn't do anything. So they're just going to not respond. And then we default them and go through that process. But if it really is someone who thinks they have a right, then they're going to file a responsive pleading, right? And then they might file a cross complaint. And now we're defending some other action and, might be accounting, right? So say we're fighting over who gets a property and who has rights to it. Well, maybe I let my girlfriend live in my house for 2 years, right?
Mm-hmm.
And now she's claiming an ownership interest in it. Or I put her on title because I was trying to be nice and now we're breaking up and I want her off a title. Well, she might want money, right? She might want rent. All kinds of things go into these things as far as who's entitled to what. And when things go bad, they go really bad. In many cases. So, people, all the best intentions, all thinking, right? So one of the things I always say is get a prenup, right? Plan ahead. I know it's not very romantic, but, and it's the same with business, right? If you're going to get into partnership and co-own a property with someone, just even if we are voluntarily agreeing to it, have something in writing as to what's going to happen with the property, who gets what each person's contribution is, what are the triggers for sale, right? So, because, now you're in bed, it's like getting married when you go on title with someone. And if we're going to break up and we have to deal with that, the more that we've planned, the easier and quicker it goes.
Yeah. Well, how much does it typically cost to do, or what is a range for a quiet title action or getting somebody basically clearing up a clouded title?
Right. Well, if we can get cooperation, but it's an attorney's involved, you're probably looking at $1,000 or $2,000 of us writing letters and negotiating and drafting up agreements and things like that. If we're going to court, you're not getting in and out for less than $10,000 to $15,000 between our costs, the court costs, the filing fees, the publication fees, right? All that kind of stuff. That's probably your best case scenario is 10 to 15. If it's disputed, it could be $100,000 or more of legal fees to fight out something.
Can you give us an example like of a difficult quiet title action that you had without like obviously disclosing any personal info?
Yeah. It really goes to who believes they have rights and what they are. So, whenever there's some sort of claim and dispute over rights, where there's an actual dispute, both sides are going to be very entrenched in their position relative to ownership and relative to rights, as far as, who's entitled to, whether rent is owed, whether there's claims. So you go into partnership and then one person makes a bunch of repairs. So who's entitled to the increase in value because of the repairs, right? I had one, the boyfriend and girlfriend, don't buy a house with your non-spouse. So they bought this house. She left, right? They broke up. She left, but she's still on title. He's remarried to someone else, right? And but she's not on title because the ex-girlfriend's still on title to the house, right? Well, guess what happens? He dies, right? So now the wife is suing the ex-girlfriend to get her off a title so that she can own her house that she lives in, right? That's the kind of crap. And
That happens.
yeah, and a lot of money, a lot of stress, a lot of anxiety, a lot of time. We did eventually get the girlfriend off a title, but it was quite a process, and she didn't go for free.
Costs money,
Yeah,
basically.
yeah.
What is a clouded title? When people say that the title is clouded, how
Right.
how what is that? And then how does title insurance protect a clouded title as well?
So a cloud on title is something that is impairing your rights, right? So a deed to a third party could be a cloud, or a fake deed. Like, unfortunately, real estate fraud, one of the things right now that we're seeing is people impersonating owners and transferring title, right? So a deed from someone who really isn't the owner would be a cloud on title. But also a lien is a cloud on title, right? So it affects your ability to sell because you can't sell and get title insurance with any sort of encumbrance on the property, voluntary or involuntary, right? So a tax lien, which is involuntary, would still be a cloud, right, on title. Some sort of claim against the property could be a cloud, right? So all kinds of different things can be clouds. Traditionally, so title insurance is a very weird type of insurance because it when we buy insurance, we're generally insuring against a future event happening, right? So I buy car insurance with the hope that if I get in an accident, I get my money back, right? I get a new
Hmm.
car, right? I get medical care, right? Depending upon what type of insurance I buy. If I buy homeowners insurance, I'm getting insurance to so that if my house burns down in the future, right, that there's money to help me rebuild my house. Right. So most insurance that we buy, I buy life insurance with the thought that I might die someday, right?
Hmm.
And there's some money for my family. Well, title insurance insures the past, unlike other insurances which insure the future. So when you buy a property and you buy title insurance, it is saying that you are the owner of that property. And it's designed to defend against a claim from someone that has a claim that's older than yours. Because again, remember how I talked about priority is based on timing. So somebody that records something after you is behind you in priority. Somebody that records something or does something before you is higher in priority. So title insurance is designed to say your deed is going to ensure that you own this property. If someone comes and says, "No, I own it. I have this claim from 5 years ago," that is what's protected. A lot of what title claims are is encroachments where like your house is hanging over your neighbor's lot line, or easements, things like that. A lot of title insurance deals with that. Or a bad deed in the past. Maybe there was a fraudulent deed somewhere in the chain of title, right? Well, that's insured under a title insurance policy. So if the person who signed your deed really isn't the owner, you're insured against that, right? The title insurance company is
Hmm.
insuring that. So, but it's the past, and so a cloud in the past, or something that comes up that becomes a cloud that is prior to your ownership, is covered by title insurance. But anything that happens after you own it is not covered. So, and one of the things people screw up, don't realize, is that, so say they transfer their property into their trust, they need to get their title insurance endorsed so that the trust is now the beneficiary of that title policy. If not, if there's a claim, it won't be covered. Or if they move a property into an LLC, for example, you want to get an endorsement on your title policy so that the LLC can have the coverage in case there's a claim about title from the past. So one of the kind of weird things about title insurance, because you want to keep it in place, but if you do certain things, it will destroy the coverage. So that if some claim from way before comes up, I just had this. Someone called us that she had an encroachment issue and she wanted us to go after her neighbor. And I said, well, did you make a title claim? Right? That's the first place to go. And so she made a title claim, and she had transferred title between herself and an entity, and it blew her coverage. So she didn't have coverage. So now she needs us to go after her neighbor, which if she hadn't blown her coverage, her title company would be paying the costs instead of her paying her attorney's fees to deal with something that occurred before she owned the property, right? The issue is pre-existing.
Got it. I love it. So moral of the story, title is like cash. You said, take care of it. Do not let people hold on to it.
Correct.
Or and be careful who you add on to title. And
Yes.
if you do add people onto title and they're really not owners, just be very, very careful because it could create problems for you. And like worst case scenario is a quiet title action, which could take years to clear up, and it could cost anywhere from $10,000 to $30,000 or
Correct.
even a couple $1,000s. So if somebody is going through a situation like this and they want to get advice or hire a company, how would they go about doing that?
Yep. The easiest way to reach us is through our website. It has our information and you have all of our contact. Our website is relawapc.com, relawapc.com. And we have informational videos. We have a lot of data and information that can help people kind of understand their situation. We do free consultations. So if people have questions, they're free to call us. We'll talk to them about their situation, see if it's something we can help with, or if not, maybe give them some direction, at least point them in the right direction to work through whatever they're dealing with.
Awesome. Well, Jennifer, I want to say thank you for coming on the show. To our viewers, thank you as well, too, for taking the time to watch. For our viewers, we had Jennifer Felton with ReLaw. We talked about quiet title action, and we talked about the importance of just being very careful who you add and remove from or who you add onto the title. If you've enjoyed this episode, make sure to hit the subscribe button. If you feel that this episode would be helpful to somebody, make sure to hit that share button. Thank you again, Jennifer, and to our viewers, until next time.